Thank you, Mr. Lebow, very much. Mr. DeBofsky.
Chairman Baucus, Ranking Member Grassley, members of the Senate Finance Committee. Thank you for giving me the opportunity to testify at today's hearing. When the Employee Retirement Income Security Act was passed in 1974, one of the law's major sponsors, Senator Jacob Javits, hailed it as the greatest development in the life of the American worker since Social Security. That optimism was secured by a promise contained in the preamble to the statute proclaiming ERISA's purpose: to provide appropriate remedies, sanctions, and ready access to the federal courts. Yet the story told over the past 35 years has been one revealing an utter betrayal of those lofty goals and an egregious absence of remedies, sanctions, and access to normal federal court procedures. Contrary to the clearly expressed legislative intent, the courts have transformed ERISA into a shield that protects insurance companies from having to face the consequences of unprincipled benefit denials and other breaches of fiduciary duty. Claimants are denied the right to trial by jury, a basic constitutional right routinely available in every other type of insurance case, in virtually all other civil litigation. In most cases, there is not even a trial. Instead, courts conduct reviews of claim records assembled and shaped by self-serving insurance companies. Claimants are given no opportunity to cross-examine adverse medical or vocational experts. Routine discovery procedures, such as compelling answers to written interrogatories and depositions, are denied, and no trial is held. No provision of ERISA sanctions such a practice, and Supreme Court precedent establishes the impropriety of courts holding review proceedings rather than trials in cases such as this. This insidious practice has also led to courts' willingness to overlook wholesale flouting of ERISA claim standards developed by the Department of Labor. Courts allow insurers to unduly delay claim decisions and deny benefit claimants any opportunity to rebut adverse evidence without any adverse consequences. Conversely, unsophisticated claimants who fail to meet complex and detailed rules governing the submission of claims and appeals are given no leeway whatsoever and are often barred from presenting crucial evidence in court if they are even able to gain access to judicial review. And even when claimants win, instead of simply ordering the payment of benefits when the benefit denial has been overturned, the routine practice is for courts to send the case back to the insurance company. Since insurance companies understand they will be given further opportunities to develop new reasons for denying the claim, there is no incentive to make an accurate decision in the first instance. Consequently, the practice of remands clogs the federal court system with multiple rounds of litigation. Following the 1989 Supreme Court ruling in Firestone Tire v. Bruck, a vast transformation of ERISA litigation arose. So long as particular language is written into the insurance policy, courts are compelled to defer to the insurance company's determination unless the claimant can prove the benefit denial was arbitrary and capricious and not merely wrong, a concept that has been elevated above the goal of assuring an accurate claim decision. As one court has remarked, the broader that discretion, the less solid an entitlement the employee has. My written testimony contains numerous examples of how this is played out. The reason most frequently offered for preserving the ERISA regime is that the current state of the law holds down costs and thus encourages the formation of employee benefit plans. But that rationale is hardly a justification for a system in which courts give more deference to insurance companies than is given to federal administrative law judges adjudicating Social Security claims. Since employee benefits are a valuable tool utilized by employers to recruit and retain prized employees, it is extremely unlikely that employers would cease sponsoring benefit plans. Nor is there a legitimate fear of markedly increased costs. The only available actuarial study on this issue reveals that potential cost increases resulting from the elimination of insurer discretion would lead to at most a modest 4% rise in insurance premiums. To analogize, both history and common sense suggest that most consumers would willingly pay a ticket charge of $104 to fly on an airline that has a near-perfect safety record rather than paying $100 to fly on an airline perceived as being less safe. That price is a small one to pay for the assurance of more solid rights to receive benefits when they are needed in times of sickness or injury, and to have confidence that those who deserve benefits receive them expeditiously, while those who are not deserving are denied for valid, defensible reasons. The ways in which ERISA can be amended to bring about these changes are not unduly complex. One possibility would be to amend the definition of welfare benefits in ERISA to clarify that the purchase of insurance as a means of funding employer-sponsored disability, health, or life insurance excludes the resulting plan from ERISA altogether, leaving claimants with the existing protections of already well-established state laws, rights, and remedies. Another proposal would be to amend Section 502 of ERISA to provide the claims brought under insured plans will always be adjudicated in accordance with the same plenary standards and proceedings afforded any other civil action brought in federal court. These proposed changes would restore the intent and purpose of the comprehensive benefit reform enacted by Congress more than 35 years ago. More importantly, such changes can help rebuild public confidence in insurance companies that have, for too long, been able to hide behind legislative shields and judicial protections that no other industry receives. Thank you.
Thank you very much. Mr. DeBofsky, that's very straightforward and very clear. Thank you. Judge Acker.